does the statute say what manner of delivery of the notices? In other words, does it matter if it is sent by regular mail, certified return receipt, or if it's hand delivered?
So the
statute, that's up to the landlord, I guess, how much they want to be able to prove that the tenant got the notice, right?
Yeah, I mean, it really, as far as how it's delivered, I mean, it needs to be, obviously, I mean, if the landlord sent it to like the wrong address or put it like under the mat or in a way that there was no way for you to get it, I mean, I guess that would be an argument. But as far as the specifics, I mean, check the lease agreement too, because sometimes the lease may address how notices are normally given and how they expect notices to be given to them. And it may just go back and forth about that. So I guess, I mean, it really just depends.
Yeah, I mean, that's a good point. It does depend on what your lease says, because a lease might say that it has to be by certified mail. That just goes back to the point, that was made earlier, that every case can be different. And it's all about what can be proven in court. And so I think that as tenants, you have to be careful that you don't ignore any notices that you actually see. And as a landlord, if you're a landlord, you want to be sure that you can prove in court that you did give whatever notice is required. And, I would think that the best practice for a landlord would be to do that either by hand delivery, where the landlord can testify under oath that they delivered it to the tenant, or certified mail. I don't think it has to be return receipt, but I think that would be preferred. But as long as you can certify that it went to the address of your tenant and was actually delivered, then it is up to the tenant to check their mail. And ignoring your mail is not, I don't think, you tell me, Holly, because again, you're the one that's in housing court more than me, but I would think that that's not a good excuse.
Yeah, definitely check your mail, but also, once again, everyone needs to read their leases thoroughly and make sure that they understand the terms of their lease, all the terms of their lease, especially pertaining to what it is they're unsure of, because that could potentially answer their questions, because everyone's situation is different. All lease agreements are different.
Yeah, and I'm sure that, that's something that we do as lawyers when there's a document that governs the situation, like a lease does when it comes to eviction. The first thing that you, I'm sure, as a housing lawyer do is to review the lease.
Yes.
And see what the lease says. Then you can start to look at the facts of a particular case and decide what defense there might be. And so, see if I can see anything else. Oh, there's so many. But I'm trying to get to them all that you haven't already answered. Okay. I think you could answer this one pretty easily. Can the landlord use the lease as notice of the violation?
No. So that's a really good question. No, they cannot use the lease agreement as a notice of, and I'm assuming they're talking about the 14-day notice. Yeah, no. That's for the statute lays out that it is an option when it comes to a notice of non-payment. When it comes to the notice to cure and all of that, you cannot put that in there, because how are they going to know how you're going to breach the lease? And they have to specify what the breach is, or what it is you did, what you didn't do to breach the lease agreement, and they can't possibly know that before you do it. And they have, so that's not proper. Just put it in.
And I think that answers the next question that I was going to read out to you, and that is how specific does the notice have to be? Does it have to clearly spell out that the lease is violated? And I think that you just answered that. It does have to clearly spell it out, and it has to say exactly how it was violated. And for a landlord, the best practice is to say what section of the lease they're talking about was violated, and then tell you, how you violated that.
Yes, it's important for, and when it comes to like if an action is brought for alleged lease violation, it's important for the person to know what the tenant to know what the alleged breach is, so they can respond, they can defend themselves. If they didn't do it, that's their defense. If it's not actually a violation of the lease agreement, then they'll know what they're being accused of, so they can make that argument. But otherwise, if it's, oh, you breached the lease, well, how?
Right. And the next question is, are there any things that will not require that notice, like illegal activity or something of that nature?
Yeah, illegal activity, absolutely. That's a big one, and I could kick myself for not doing that.
But they still get the notice.
Oh, I'm sorry.
I think the question was, do they still have to give you notice, even if it's something illegal, like illegal activity?
Well, notice, I mean, not the 14-day notice to cure, but definitely like, that notifying you that you've breached the lease. It could be like a notice of termination under that, but that's actually, but not a 14-day notice to cure though. That's not required when it comes to illegal activity.
Okay. Let's see. Can your landlord send you a request for rent on the day it is due, like using Zelle or Venmo? Can they send you, I guess you can send a pay request in other situations, but is that something that a landlord can use to request rent from you on the day that it's due?
I'm not aware.
They can, but whether or not you have to do it is another question.
Yeah, I'm not aware of any rule that says that's not okay. I know this just kind of goes back to the whole, everyone's lease agreement is different. The landlord-tenant relationship may be different. An individual as a landlord versus a property management company. I mean, everyone runs that, everyone's different on the way that they handle, rental payments and how they want the rent to be paid and how the mode for which they'll accept the rent. So as far as I know, that there's nothing wrong with that. If that's how they
look at the lease, right?
Right. Yeah. Once again, look at the lease.
Now there is a question regarding retaliatory eviction, or I guess wrongful eviction, and the treble damages idea. Is it 3 times actual damages or 3 times the rent, or is it the greater of the two? And I think the statute addresses that.
Yeah, it does. And I can't remember off the top of my head. But
we can provide that in the comments.
Yeah, but it's definitely laid out in the statute with the damages.